Jan Logie.
Thank you, Mr. Chair, and it's a pleasure to rise and speak on behalf of the Green Party in the committee stages of the Hurunui Kaikōura Earthquakes Recovery Bill, which the Green Party is supporting. And I too want to add my voice of thanks, along with the other members of the committee, to the committee staff and the officials and the Minister, indeed, who have put in a huge amount of work to enable us to get to this point. It's very clear, as the mood in the committee indicated, that we all want to get this right, that these are extraordinary powers that are being handed to the executive, and that is something that should never be taken lightly or done in a sense of panic or emergency without very proper consideration. And I've been encouraged that there has been a significant amount of thought about what checks and balances we could practically put in place that would help good decision making. Because in the heart of it, this is about preventing, those checks and balances are about preventing a misuse of power, but they are also about making sure that we get good decisions for communities that are already in a really terrible situation. And we know that in times of extreme stress, which there's no doubt that the people in Kaikōura and Hurunui must be feeling extreme stress at the moment and will be for a significant period of time, that in those times there will be a temptation to just get things done, but that sometimes that may lead to poor decision making that will have irreparable consequences. So part of this process is putting in some checks and balances to prompt a second thought from that first option and idea that we may all be compelled to. So some of the changes that happened within the Select Committee process were that there's been a reduction in the number of acts that can be changed easily by order of council, and I think there are 8 fewer acts on that list. So that also shows that the ministries who are thinking about what might be needed in these areas have gone through and thought a bit more carefully than their first take about actually how could we do this? How could we support these communities? And where could we do it within the existing law? And where might we need a bit of override of current legislation? And we had some concern at the beginning that there's a provision in here that enables additional acts to be added to that list. So that remains, that additional acts can be added, but for an act to be added, that the Minister needs to send a draft of the intention to do that to the leaders of all of the parties in Parliament. And there needs to be near unanimous support from those party leaders for that to go ahead. So that is giving some of that power back to Parliament, and which is a balance of the power of the executive. And that seemed to us to be a good compromise, because we do understand that we cannot anticipate what might happen, or indeed what is invisible to us at the moment that may only become clearer later. So there was also concern for us at the beginning in the bill as it went to the Select Committee, that there was a provision that said, and I can't remember the exact wording, but that things could not be challenged in the court. And there was a very real concern on the committee that that meant judicial review of any of the orders in council were ruled out, that there could be no scrutiny of these orders in council by the courts. And that seemed concerning, to put it mildly. So that there has been some clarification of that, and there was a negotiation in that process. And while the committee is not unanimous in support of the point we got to, Mr. Chair.
Chair Logie.
Thank you, Mr. Chair. And we would have liked to seen possibly a clearer or ability for a review beyond whether an act is authorised or an order as council is authorised by this act. However, it is a compromise point that all parties could live with, at least, even though the Green Party would have gone further. And there was a part in the Act that talked about if there was another quake that happened or a significant event or a tsunami that impacted on affected areas, then orders in council could be applied to those other areas. So the example that we discussed in committee was if there was an earthquake in Hawke's Bay or a tsunami and that affected one of the regions in New Zealand that was covered by this piece of legislation, then actually you could use orders in councils in Hawke's Bay or up in Auckland just by virtue of this act. The committee and the minister agreed that that was a step too far, that actually if there was an event of that nature, then Parliament should reconvene to consider exactly what bespoke response was needed to that event, and that should not be able to be dealt with by this piece of legislation. And that is a good improvement, I would say. We also had a bit of concern in the initial draft that we'd seen before it coming to the House. There'd been the ability for affected people to be able to provide comment into the process. And then the bill that came to the House didn't include that. And we were concerned about that. Though it was an interesting discussion in the committee, because asking Professor Geddes about whether he supported that provision through the submissions, he was saying, well, actually, if you specify it needs to be affected people, then actually you're opening to a legal challenge on the basis that you didn't identify all the affected people. So that actually seemed a reasonable point, and why we wouldn't want affected people locked into the legislation. But what we have, and I thank the Minister for it, is a provision that in the drafting of an order in the council, if it is practicable, then the Minister will either contact and give a copy of the draft and reasoning to people that the Minister considers will be affected by the legislation, or will publicly notify it. So there's an opportunity for people in those communities to be able to have a say, potentially, in that drafting phase of an order in council. And we strongly believe that that input will help make good decisions. It gives the Minister the opportunity to get more information, to be able to weigh up the different potential impacts of an order in council, and we thank the Minister for adding in that provision. We did also have, I guess, some concerns about the breadth, how wide the purpose of the Act is. And there was debate about that within the committee. It has been tidied up from where it was initially, and thank Dennis O'Rourke for his contributions towards that. I do recognise that it is a very difficult balance between you make the purpose so wide that really nothing's challengeable in the courts, versus you make it too tight and you can't respond to the events that arise that you cannot foresee. So I think we were willing to accept where it got on the basis of, actually, it's a really difficult decision to make, and it's probably one of those things that I hope there'll be an evaluation of how this works after this time is over, so that we can consider, was the purpose scope too wide or not? And we look forward to that discussion in the future. And I see that my time is running out on this, but really do just want to say that it was a very constructive process that reflected the concern right across the House for the people and the communities who have been affected by this quake.